Which story is the right? That's the right thing to do. Looks like we're going to have a presentation of information. Yeah, I'll be out. Looks like I will do a presentation.
What he said?
With a what? Okay, yeah, that's perfect.
There's just the one screen.
Stand up.
If you would like to have us email those to you, if you would supply us with an email, we'll be happy to do so. On Wednesday, April 21st, 2021, Andrew Brown Jr. of Elizabeth City, North Carolina, was shot and killed by 3 deputies with the Pasquotank County Sheriff's Office. This incident occurred at the residence of Mr. Brown, located at 421 Perry Street in Elizabeth City, North Carolina. After reviewing the investigation conducted by the North Carolina State Bureau of Investigation, Mr. Brown's death, while tragic, was justified because Mr. Brown's actions caused 3 deputies with the Pasquotank County Sheriff's Office to reasonably believe it was necessary to use deadly force to protect themselves and others. While the officer-involved shooting that resulted in the death of Andrew Brown occurred on Wednesday, April 21st, law enforcement involvement with Mr. Brown began in the weeks prior and put the wheels in motion that eventually led to the attempted service of arrest and search warrants on April 21, 2021. In the early months of this year, Detective Johnson with the Dare County Sheriff's Office received information from a reliable confidential source that Andrew Brown Jr. from Elizabeth City was selling drugs in Dare County. Detective Johnson contacted Pasquotank County and confirmed Mr. Brown's identity and that he is a known drug dealer. Upon learning this information, Detective Johnson, with the aid of the confidential informant, made 2 undercover buys from Brown on March 17th, 2021 and March 29th, 2021. Those buys were of cocaine and heroin, respectively. A later SBI lab analysis determined that the heroin was laced with fentanyl. Subsequently, arrest warrants were issued for Brown's arrest on April 20th, 2021. Simultaneous with the activity of the Dare County Sheriff's Office, Pasquotank County Sheriff's Office began collecting their own intelligence on the drug activity of Mr. Brown at his residence at 421 Perry Street. Detective Ryan Meads applied for and obtained a search warrant for the residence and vehicles of Mr. Brown. On Tuesday, April 20th, 2021, law enforcement now possessed 2 arrest warrants for the sale of controlled substances in Dare County, as well as a search warrant for the residence and vehicles of Mr. Brown. A joint team of law enforcement from Dare County and Pasquotank was assembled. The Dare County Drug Task Force was to provide surveillance, and the officers present that day were Detective Johnson, Sergeant Ruth, and Detective Langley. The Pasquotank Special Operation and Tactics Team would serve the warrants. Warrants on Mr. Brown. During the briefing conducted by Sergeant Meads, the team was briefed on Mr. Brown and his past involvement with law enforcement. It was relayed to the team that Mr. Brown has multiple resist arrest charges and convictions dating back to 1995. Additionally, Mr. Brown has assault with a deadly weapon, and assault inflicting serious injury convictions dating back to 95. Further, Mr. Brown has barricaded doorways during previous home search warrant instances. No children were believed to be at the location, and the mother of Mr. Brown's minor children was seldom at his residence. At approximately 8 a.m., Mr. Brown was located on Speed Street here in Elizabeth City by one of the members of the Dare County narcotics team. Mr. Brown then drove his vehicle to his residence at 421 Perry Street and remained in his vehicle until law enforcement arrived. Upon receiving this information, the Pasquotank County team traveled to 421 Perry Street to serve the warrants in a clearly marked Pasquotank County Sheriff's Office truck with blue lights and emergency lights flashing. Detective Langley from Dare County drove the vehicle, and Deputy Lunsford was in the passenger seat. The remaining members of the Pasquotank County team were in the truck bed as the truck was en route. Upon arriving to 421 Perry Street at approximately 8:23 a.m., Mr. Brown was still sitting in his vehicle beside the residence. Detective Langley pulled the Pasquotank County truck in the driveway with his right front bumper close to the front bumper of Brown's vehicle to block any forward motion, and Brown was still seated in the vehicle. Weapon drawn and attempted to open the door. Deputy Swindale accompanied Deputy Lunsford to the driver's side of the car. Deputy Llewellyn went around the Pasquotank County truck and approached the vehicle from the front passenger side, and Deputy Bishop Would you like to do this manually? Deputy Llewellyn went around the Pasquotank County truck and approached the vehicle from the front passenger side, and Deputy Bishop and Sergeant Meade he approached from the passenger side, Deputy Bishop, Sergeant Meade, Brown threw the phone down and began to rapidly back his car away from the officers. Have you taken it out? Am I completely offline at this point? You need to back up to about 5 slides. If you'll leave it right there. You're at photo 11. If you would back up to photo 6. All right. Thank you. Andrew, at this point, I will just give you the nod to move forward, okay? Brown threw the phone down and began to rapidly back his car away from the officers. Deputy Lunsford's hand was still on the driver's door handle as Brown's car reversed and the handle was snatched out of his hand. At this moment, Deputy Lunsford yelled out, and Deputy Lunsford was pulled over the hood of Brown's vehicle, where his body and his safety equipment were struck by the vehicle. Deputy Lunsford's left arm was squarely on the hood. Deputy Lunsford took evasive action to get out of the way of the front left tire of Brown's vehicle, and law enforcement commands became more heated, with profanities shouted for Brown to stop the car. Brown ignored the officer's commands and backed his car until he was blocked by the rear of his residence. Continue. Continue. Right there. Brown then put the car in drive and turned the steering wheel left, directly at law enforcement officers who had now Deputy Lunsford used his left hand to push off of the hood. It was at this moment that the first shot is fired. Deputy Lunsford then spun out of the way to avoid being run over by Brown's vehicle. One more. According to the North Carolina Justice Academy forensic analyst Cason Reynolds, the first shot was fired by Sergeant Meads, and it entered the front windshield of Mr. Brown's car. Let me say that again. It entered the front windshield of Mr. Brown's car. Brown's car continued forward, passing Deputy Lunsford, Deputy Morgan, and Sergeant Meads, and several shots are heard. One shot entered the passenger window and struck Brown in the shoulder. Several more entered the rear passenger side door and window. Brown's vehicle then accelerated across the vacant lot next to 421 Perry Street, and 5 additional shots entered the rear windshield and trunk of Brown's vehicle. At this moment, Brown was driving directly at Investigator Johnson, who was positioned on Roanoke Avenue in an unmarked white van. Lieutenant Judd was positioned on the corner of Roanoke and Perry in an unmarked white Crown Victoria. Brown's car narrowly missed striking the van operated by Investigator Johnson, who accelerated to avoid the collision. Brown's vehicle crossed Roanoke Avenue and struck a tree in the residence on Roanoke Avenue and came to rest. The Pasquotank County team gave chase, removed Brown from the driver's seat, and life-saving efforts were immediately begun. At 8:24, deputies notified dispatch of shots fired. Emergency medical services were requested at 8:26 a.m. The aforementioned Pasquotank County Sheriff's officers. The total length of officer involvement with Mr. Brown from the time they exited the vehicle until Mr. Brown was removed from the vehicle is 44 seconds. I'm now going to show you the 4 body cam videos that depict law enforcement activity with Mr. Brown on that day.
Go, 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 go! Motherfucker! Stop the fucking car!
Andrew Brown case. He was shot dead by deputies back on April the 21st. That was being served. Detectives used an undercover. So a team of deputies from the Pasquotank County, from Dare County, went out to that home on the morning of April 21st to serve warrant. District attorney, they announced themselves, and you're looking. District attorney, they announced themselves.
At our office here in Elizabeth City and to proceed with me to the scene of the incident. We viewed the scene, and later that day, I met with Sheriff Wooten, Special Agent Rogers, members of the SBI team that would conduct the investigation. On May 11th, 2021, the SBI lead case agent, Jason Godfrey, began releasing the SBI report gathered to the district attorney's office. I immediately began review of the written SBI reports and other documents as investigated by the SBI. I reviewed the SBI investigation, which included interviews of the deputies involved with the Pasquotank County Sheriff's Office, interviews of civilian witnesses, interview of Dr. Karen L. Kelly, a forensic pathologist at the Brody School of Medicine at East Carolina University in Greenville, photographs of the scene, ballistics and trajectory report of Cason Reynolds, analysis of weapons and shell casings, the law enforcement personnel records of the deputies involved, video footage of the body cameras at the scene, and the crime scene report. In addition, I have met or had telephone contact with Jason Godfrey practically every day since April 21, 2021. Agent Godfrey and I viewed the trajectory rod analysis performed by Agent Candace Pegram and assisted by Agents Rob Evans and Stephen Stile on April 22nd, 2021. Further, I sought advice and counsel from numerous elected district attorneys around the state who have had recent experience with officer-involved shooting cases. There are 14 houses near 421 Perry Street, and each location was canvassed for evidence and witnesses. 4 civilians provided statements to law enforcement. Ms. Demetria Williams stated she lived in the vicinity of 421 Perry Street and heard gunshots from inside of her residence. She further stated that after hearing the first shot, she exited her home, went down the street, and saw the remainder of the shots being fired. Ms. Williams' home is approximately 100 yards away from 421 Perry Street. The total elapsed time from the first shot to the last is 5 seconds. Brown commands to get out. The third civilian to give a statement was Ashley Bechtel. Ms. Bechtel stated she did not see the initial shots fired, but heard them and went to her window. She stated Brown's car was heading over Roanoke Avenue and the officers were forceful when removing Brown from the vehicle. Bechtel further stated she heard additional shots after Brown's vehicle struck the tree and as officers approached the vehicle. The fourth civilian to give a statement was Amber Santiago. Ms. Santiago stated she was in a relationship with Mr. Brown and stated they had a telephone conversation the night before where Brown stated he believed the police were following him. Ms. Santiago further stated that Mr. Brown said he was going to stay at a hotel rather than staying at his residence at 421 Perry Street. The weapons used by the three Pasquotank County deputies who fired were two Glock 17 handguns and an AR-15 .223 rifle. These weapons were seized and provided to the SBI. The SBI recovered 14 spent shell casings, 9 from the Glock 17 handguns and 5 from the AR-15 rifle. These 14 spent shell casings were recovered from the cement driveway and in the yard adjacent to 421 Perry Street. These 14 shell casings were consistent with the body cam videos and physical examination of Brown's car as being fired by the deputies. On April 21, 2021, Mr. Brown's body was transported to the medical examiner's office in Greenville, North Carolina, where an autopsy was performed. The autopsy was conducted by Dr. Karen L. Kelly, a forensic pathologist of the medical examiner's office at the Brody School of Medicine in Greenville. That was done on Thursday, April 22nd, 2021. The autopsy was witnessed by Special Agent Cowan with the North Carolina SBI, and a written report was produced of the findings. Although the autopsy and toxicology reports have not been finalized at this time, I had telephone contact with Dr. Kelly on May 12th, at which time we discussed her findings. Dr. Kelly determined Brown suffered 2 gunshot wounds, one to the right shoulder, upper arm that was non-lethal, and a second wound to the back of the head at the base of the skull near the hairline. There were 3 bullet fragments recovered from the wound to the back of the head. Dr. Kelly found multiple abrasions on Brown's right arm, right leg, and on his back. Dr. Kelly advised me that these injuries were superficial and appeared to be made by shrapnel. Additionally, Dr. Kelly recovered a plastic baggie containing an off-white, rock-like substance from inside of Mr. Brown's mouth. The substance is consistent with crystal meth and was the size of a 50-cent piece and too large to swallow. Dr. Kelly determined the cause of death to be multiple gunshot wounds. Deadly force may be used if it appears to be reasonably necessary. Ended immediately. The North Carolina General Assembly has codified this case law in our general statutes at NCGS 15A. But must make allowance for the fact that police officers are often forced to make split-second judgment in circumstances that are tense, uncertain, and rapidly evolving. The law authorizes an officer to take preemptive action and use deadly force to prevent death or serious injury to himself or herself, provided that the threat assessment is reasonably made. Whenever officers use deadly force to defend themselves or to stop a dangerous fleeing felon, the determination of whether they properly used that force focuses on whether the totality of the circumstances as they appeared to the officers at the time of the killing were sufficient to create a belief in a reasonable person standing in their shoes that such force was necessary. In short, assessing the reasonableness of the shooting requires examining the perspective of a reasonable officer on the scene. Consequently, my focus was on the relevant set of facts a reasonable officer in the deputy's position would have experienced. When weighing the degree of force used, a prosecutor must pay careful attention to the facts and circumstances of each particular case, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. Using these parameters, I find that the facts of this case clearly illustrate the officers who used deadly force on Andrew Brown Jr. did so reasonably and only when a violent felon used a deadly weapon to place their lives in danger. First, when assessing the severity of the crime at issue, Andrew Brown Jr. was being served with 2 felony arrest warrants and a search warrant. The law enforcement officers were duty-bound to stand their ground, carry through on the performance of their duties, and take Andrew Brown into custody. They could not simply let him go, as has been suggested. Additionally, Brown engaged in dangerous felony-level misconduct as he attempted to flee from law enforcement officers. The decision to flee, which Brown made on his own, quickly escalated the situation from a show of force to an employment of force. Brown's precise speed in attempting to flee and striking Deputy Lunsford is uncertain, but that he drove recklessly and endangered the officers is not uncertain. Therefore, I find that Brown's actions and conduct were indeed dangerous by the time of the shooting. Second, Brown was actively resisting arrest and attempting to evade arrest by flight before, during, and after the shooting. All officers had been briefed on Brown's previous interaction with law enforcement, including his propensity to resist and barricade himself. Briefings also informed these officers of Brown's prior criminal history and the fact that he has attained the habitual Roanoke Avenue in Perry and a white unmarked Crown Victoria. threat of harm. As the United States Supreme Court has observed, the calculus of reasonableness must allow for the fact that law enforcement officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. From a review of the body camera video from the scene, there is evidence that multiple shots were fired in rapid succession by 3 deputies. There is no evidence that the number of shots fired by the deputies was excessive, but even if there are an excessive number of shots, the question is whether the perceived threat has been neutralized for the safety of law enforcement officers present. In this case, the deputies used the amount of force deemed reasonably appropriate by them to neutralize a perceived threat. Based upon my review of the facts of this case, I have determined that the shooting of Andrew Brown on April 21st, 2021 was justified to protect the safety and lives of the deputies on the scene. The deputies who fired the fatal shots perceived an actual and apparent threat, evaluated the situation in seconds, decided, and acted. The deputies' actions appear reasonable under all the circumstances of the case. The deputies faced both actual danger and apparent danger as perceived by them on the scene. This apparent threat was reinforced by Brown's dangerous and felonious use of a deadly weapon. As tragic as this incident is with the loss of life, the deputies on scene were nonetheless justified in defending themselves from death or great bodily with the threat they perceived, and certainly no evidence that the deputies acted in any way contrary to or in violation of North Carolina law. I appreciate the investigation by the North Carolina State Bureau of Investigation's District Field Office. I have shared this conclusion with Sheriff Tommy Wooten and Special Agent in Charge Mache Rogers that no officer will be criminally charged. The officers' actions were consistent with their training and fully supported under the law in protecting their lives and this community. Confrontations between police and citizens in which deadly force is used are among the most important cases the District Attorney's Office will ever handle. My prosecutors and I have a duty to objectively analyze the totality of the evidence and circumstances, and that means we must face difficult issues which have been discussed at length in this report. It is my sincere prayer that no one is ever killed by law enforcement. But I also pray that law enforcement are never placed in the position of having to make the decision to use lethal force to protect themselves or innocent lives around them. I want our community to understand that this office put significant effort into ensuring that this decision was based on the facts, the evidence, and the law, and not on public opinion. In describing the legal analysis and the basis for the decision, was not released to refute these untrue statements. I have always asserted that my office would strive towards transparency, but I need everyone to understand that among my highest priorities is also protecting the integrity of every investigation. Releasing information before any investigation is complete can taint the case. Preventing an objectively verifiable investigation and perhaps even the possibility of prosecution. In an ongoing investigation, details are closely guarded to help measure the truthfulness of witnesses and, should someone be charged, preserve the defendant's right to a fair trial. I know that a lack of accurate information is frustrating to the public and the media that operate on a 24-hour news cycle. But in this age of instant media and the impulse to immediately form an opinion, I'm asking that as we move forward, we remind ourselves that in these cases, we should not jump to conclusions until all the facts are out. I will always be guided by my oath of office, by the United States and the North Carolina Constitution and the North Carolina General Statutes. Justice demands nothing less. Thank you. Yes, sir.
Do you think all the facts are out?
You've been listening to a live news conference from the Judicial District 1 District Attorney, Andrew Womble, covering Pasquotank County and Elizabeth City, scene of a fatal deputy shooting of Andrew Brown Jr. back on April 21st. The district